45.
45. I need 10 days time.
For the other side,
Other side,
any objection? Item 45 on the request made by Mr. S. Representative AEGCL. Raised for further 3 weeks' time. 5 is count the affidavit. Prayer made is not objected. It's the matter in 3 weeks. Let the affidavit be filed. You make a mention after that. We list it.
Right.
Lordship, I seeking a posting of my case number WPC by 2 months.
Admission orders, hearing,
Admission.
admission. Then let it come on 1st of June.
Consent of the others, I'd like to mention item number 47. We require 4 weeks time to file an affidavit.
Item 47 on the request made by Ms. LDV.
On behalf of A. Gauhati.
47.
47.
Mention on top of the guy. 3 weeks, 4 weeks. Submitted consent of the council. List of the 4 weeks.
May I please, Your Lordship, my lord? I'd like to mention for listing of 2 matters for admission, Lordship. One matter is pertaining to non-payment of rent, and another is selection, Lordship. Lordship may kindly post this matter on 29th of May, Lordship, subject to convenience. Friday, Lordship. 29th.
Let it be on 1st of May, 1st of June.
Both the matter.
Both them.
Keep them. I'd like to mention for listing of matter for all us, the matter is related to the SSC and Lordship had decided the issue.
1st June.
Similar prayer, Lordship, for orders, Lordship.
1st June.
I beg to mention for listing on writ petition, this matter may be taken up on 1st of June.
What is the matter about?
Petitioner was relieved from his service. He was initially appointed for 2 years as contractual. For admission, this matter may be taken.
Admission on it.
Again.
May I please, Your Lordship? I beg to mention for listing one writ petition in admission column, Lordship. For 26 May, Lordship, 3rd June. Lordship, last 2 occasions, Lordship, letter not reached, Lordship, due to positive time. Let it be on 3rd June. Keep the order.
May I please, Your Lordship, I'd like to mention for petition for admission column. Participant suspension.
3rd June.
Much of it.
Yes.
May I please, Your Lordship, with the consent of the other party, I beg to mention item 35.
35. What is your prayer? You're making a mention on whose behalf?
On behalf of Dr. H. Omar, he's out of town.
Dr. H.
H. Omar.
H. Omar. Item 35 for the request made by the council for respondent 4 stands deferred to Mr. Dr. 4.
Your Lordship,
Council for the
it may be
petitioner is for Mr. Yusoye, writ petitioner. After 4 weeks, let it come in July.
Your Lordship, this is a long pending matter and they are taking time again and again.
You are giving a job, you are giving your consent. Why did you give your consent? It is a fixed matter today.
Because these out of
We fix the matter at your instance. You give a consent. Nice, you are accommodating other council. But don't ask for fixed date. He'll come after 4 weeks, you make a mention after 4 weeks. We fix a date.
everything. I can know 11, my lord.
11.
Yeah, consent of my friend, my lord. Directed to the instruction, I am not received, my lord. So, my lord, I fix another date, my lord, on 28 May. On 28 May.
28. 28 May, no, not possible. It has to be in June.
3rd.
8th of June.
Your lordship, only thing is that the 6 months period is getting over by May. So it was listed accordingly on 20
What
today.
is 6 months for?
6 months for deducting the salary, proportionate salary from December to May. So I will be affected
Explain what direction?
Your Honor, Your Lordship, there was a minimum penalty imposed, minor penalty imposed for which 6 months the deduction was allowed under the impugned order. So it got effective with effect from December 2025. So May is the last month for my against those disciplinary proceedings. I have been imposed a penalty.
Is there any interim order?
No, my
No.
lord, it's directed to the instructions with the documents, my lord, they want to highly represent us, madam.
File an
Documents
appeal.
document not furnished, madam, that was my case. So last time directed to the
Or
instruction.
29?
From that. Yes. Separate. Item number 23. Matter has become infructuous.
Three of submissions made by the council. Petitioner, 23 contempt petition.
Contempt petition.
Submitted that the directions contained in the since right?
No, not. Respondents have preferred a writ appeal. The order of the Honorable Single Judge is satisfied.
As the directions, as the order of the court and bench. So and so passed in the by the writ appeal court by an order passed in number writ appeal number
Writ appeal number 181 of 2021.
181 of
2024.
2024. What is the date of the
Your
order?
Lordship, the date is 17/12/2025.
17/12/2025 accordingly. The action of the judgment or order of the coordinate bench being interfered with. No contempt is made out. Accordingly, contempt petition stands closed. Notices issued stand closed.
Apply to it.
But 34.
34 wanted after vacation. 34 stands deferred to be listed after 4 weeks from the request made in the outcome.
That is the motion. I beg to mention a contempt petition for listing as it was directed in the last location for listing after 4 weeks,
When was the last day?
20 March. 26.
3rd of June. Yes, instructions.
As per our instructions, my lord, from the PCCF's office, the file has been forwarded to now the secretary of the department, forest department. And in the department, my lord, it is pending with the finance and accounts officer, my lord. I asked for reasons of the pendency. So far, they have not given me a reason, but by today, my lord, I'll get the reason.
Mr. I. Bothakur, counsel appearing for the forest department submits that the papers pertaining to PI's proposal, the petitioner, is presently pending before the secretary, Department of Forests office. He submits that the reasons for such reasons for such pendency that office is not being communicated standing counsel. He submits that he would like to pray for a week's time to complete his instructions thereon. Based on 25th May, get your instructions, or we are calling your officer, Mr. Nayak, for
Finance Department.
Finance.
Usually your lordship has seen the notification issued by the state government yesterday. Lord.
what is that?
Hearing lordship, it was proposed that persons who are responsible for delay in releasing pensionary benefits, lordship, action to be taken against.
Yes, give us that notification.
Lordship.
Give it to the court master.
Apply. Thank you.
Get a काम करो. तब तक ये तो proper to knowledge couple of yes, madam, this is statement of non-compliance of the order dated by on 26/8/2025. In time order was then that they are to pay the pending salary, the petitioner. That has not been. Particular, well, this order is 26/8. Yes. What is the status of the writ petition? That is pending. So you get the writ petition disposed of? Under salary part, only for 2013 to July 2008. He submitted that by order dated 26/8/2025. Certain directions were issued for admitted areas of salary by order dated 26/8/2025, passed in WPC number 505 of 2024. This writ petition is presently pending, therefore this court is of the view that the contempt petition be listed along with WPC number 505 of 2024 after 2 weeks for orders. Salary, the pendency of the matters will not. In the meantime, because we are not issuing notice now. Yes. So therefore, there is no one to accept the direction of. Let it come after 2 weeks along with the writ petition.
Yeah, please, Lordship.
Under what? What are you praying for?
My lord, here the order passed by the Armed Forces Tribunal, Regional Bench, Gauhati, with certain directions. So these orders have been not deliberately and willfully it is not complied till date.
Let us see the contents of Court Act.
So before that, my lord, there is a provision on Armed Forces Tribunal also under section 19.
Let us see Armed Forces and contempt of court. Armed Forces. Oh, Armed Forces Tribunal. Give us a moment. Which section? 9?
Section 19.
19.
So section 19 here is a power to punish for contempt. But my lord, here it is not for the civil contempt. It is only for the criminal contempt. May I read, my lord, section 19?
Yes.
Power to punish for contempt any person who is guilty of contempt of the tribunal by using any insulting or threatening language or by causing any interruption or disturbance in the proceeding of such tribunal shall, on conviction, be liable to suffer imprisonment for a term which may extend to 3 years. For the purpose of trying an offence under this section, number 2, for the purpose of trying an offence under this section, the provision of section 14, 15, 17, 18 and 20 of the Contempt of Court Act 1971 shall, mutatis mutandis, apply as if a reference therein too. A, Supreme Court or High Court, where a reference to the tribunal, Chief Justice, where reference to the chairperson, Judge, where a reference to the judicial administrative member of the tribunal.
This is for criminal contempt.
Criminal contempt, my lord. So thereafter, what happened? The matters come before the principal bench of the tribunal, full bench of tribunal, where it is decided that yes, the cases cannot be allowed to go without implementation. So they have decided that yes, contempt lie under the section 19 and read is section 25. But again, my lord, that order has been challenged and another order is passed by Delhi High Court. Well, this is the order of Delhi High Court.
Yes.
Well, here the first para here, my lord. It is the pronounced on 23rd February 2026. A, the issue. Page 1, first.
Yes.
We are required in this petition, which emanates from a detailed judgment dated 31st July 2024 by full bench of 3 learned members of the Armed Force Tribunal, New Delhi, to interpret Section 19 and 29 of the Armed Force Tribunal Act 2007, read with Rule 25 of the Armed Force Tribunal Procedural Rules 2008. And my lord, the relevant portion here is the next page, page number 3. A brief preliminary overview. 5.1, my lord. The issue in controversy essentially revolves around the powers of the AFT to ensure that its orders are implemented as the impugn orders, order notes 5612 orders passed by the AFT were unimplemented on the date when the impugn order was passed. They resulted in a serious relook being necessary regarding the power of the AFT to ensure that its order were.
All right. Who's CGC here? Yes. Please serve a copy of the CGC. Later obtain the instructions in the matter. This is a contempt matter, but we want the assistance of the CGC.
Page number 37, my lord, of this judgment is concluded here, my lord.
What is that?
Para 87, my lord.
Yes.
We sum up our conclusion thus. Section 19 of the Act, AFT Act, does not empower the AFT to proceed against any person for disobeying a final order or judgment rendered by its disposing of a lease. And my lord, next page, my lord, serial number 4. Disobedience of any final order of the judgment of the AFT would, however, attract Section 10 of the Contempt of Courts Act and be punishable thereunder. Hence, my lord, I am before the Honorable Court under Section 10 and 12 of this Contempt of Court.
All right. Let the CGC examine the matter and apprise us. When can you do it?
I'll serve copy.
You serve copies. Let this matter be listed on 29th May.
The petitioners are the candidates for the post of constable GD, your lordship. This Central Armed Police Forces, as per the advertised.
Yes, get instructions.
Yes, Lordship, one petitioner is eligible to get benefit under the notification 2017 and others are not.
Others are not. Which
Similar-
petitioner?
Petitioner number 11. Your lordship.
Similar order has been passed by the Supreme Court.
One similar order. Can I?
Which order?
But then,
So here it is a case of petitioner number 11.
Yes, Lordship. His NCL certificate is on dated 30/12/2024. Your Lordship.
Yes,
Yes, that's it.
third counsel for parties is S. Purva, CGC. Dispose.
As that the respondent was asked to bring the instruction.
What instructions?
Actually, I am a assistant computer operator actually from 2009. From 2015, I am not getting my salary and all. That was the main case actually. Going here.
Yes, Mr. Ghosh.
Lordship, the instructions and some.
Third counsel for parties issue notice written of Mr. A. Ghosh. A. Ghosh. Here's an exception notice on behalf
All the respondents.
of the respondent. Waived
Okay, except three, Lordship.
Respondents 1, 2, and 4. And A board having for responding 3. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1. Just about it.
Last occasion, my lord, that opinion on the department was directed to the instruction.
The instructors are waiting. I need some.
Mhm.
I need some more time.
Mr. R. M. Deka for the petitioner, A.K. Ghosh for the respondent, P and the department. Please prayer for further time. Praise for 2 weeks. Praise and is granted 2 weeks further time. Days taken on 12th.
Sure.
Yes.
I have a caveat and for respond number 2 and 3.
Your caveat.
Yes.
So what I propose below, let them file their affidavit.
Issue notice.
Not very
The
sure.
only point involved in this case whether the promotion could be made without holding any interview. Very small campus.
Nevertheless, notice may be issued and we file
There are
that.
private respondents.
Yes. Yes, Lordship.
Third, Mr. Das Guptal and senior counsel assisted by Mr. S. MS M. Hazarika, senior counsel assisted by Mr.
D. Khan.
D.
Khan.
D. Khan. Appearing for
Respond number 2 and 3.
respondent 2 and 3. Who are on caveat. And who's for 1? Mr. S. Kapoti appears for respondent 1. Since the respondents are represented by respondents 1, 2, and 3 are duly represented. Since for the same respondents, we have an extra copies furnished within a period of 1 week from today. Steps on respondent 4 to 7 by speed post within 1 week from today.
5, 6, 7.
4, 5, 6.
4,
4 to
5.
7. The respondents are at liberty to complete their instructions and file necessary respondent 2 and 3 are on caveat. Zarika is on caveat. Caveat discharge.
Can be permitted to serve justice service on respondent.
Petitioner counsel is also permitted to make serve copies by way of dusty, subject to the same being noted through the registry of the court. The event service by way of dusty is undertaken, then affidavit of compliance should also be filed.
Ticket is 4, 5, and 6.
Yes.
Lordship has made the guilty notice returnable.
4 weeks.
4 weeks. Obliged.
Silent. Yes. Any instructions?
Yes, we have got instruction that yesterday hearing was formed.
Huh?
Took place. Yesterday
Hearing took place. By which, by the review authority. Review authority.
Secretary.
At page 54, Lordship direction was categorically stated that it should be completed by 6/3/2026 because the exponent number 5 was held to be illegally holding the post. It was held by the authorities itself. The
We'll
thing
give
is
you 2 weeks time more to complete
Yes,
and
plus,
pass
plus.
necessary orders. Is submitted by the standing council revenue that the hearing before the revenue authorities stood concluded today, yesterday.
Yesterday. No, first hearing was
in this
not concluded.
The hearing is underway.
Under.
He therefore submits that further time be granted to complete the hearing. Mr. A.R. Govindar, on the other hand, counsel to the petitioner, is referred to direction of the court in the order dated 28/11/2025, passing WPC number 6756 of 25. Stockman submits that in para
5,
para
last
5,
page, page 54.
para 5.
Outer limit was 6/3/2026. The outer limit granted was not 6/3/2026.
Directed the hearing and disposal of the review within period of 2 weeks from the date of receipt of the order.
Oh, the date is mentioned, 6/3/26.
Where is it?
The prior to that, that's it.
6/3.
Fifth line from the top, 54, page 54.
And you see that there is a direction that the review be filed in the prescribed time and a speaking order be expeditiously passed within a period within the outer limit of 6/3/2026. The revenue department has not furnished any explanation why the time limits specified by the court has not been adhered to by the authority undertaking hearing of the review petition. So, be that as it may, we permit the review authorities to complete the hearing expeditiously within a further period of 2 weeks from today. It is made clear that the review authorities must complete and pass the orders by 5th of June, with copies thereof being served on the writ petition. We dispose of the matter then.
Let it be, because they have not
Release this matter again on 8th.
obliged.
Instruction was short for and the appeal, the second appeal has been considered and registered is pending for the consideration for the hearing. Lordship may dispose of the petition, giving us some time. Lordship, although there is no time limit, the court may directly find
In deference to the earlier order dated 11/5/2026, Mr. D. Deka, Standing Council Assam Information Commission, has informed the court that the appeal has been registered and is ready to be taken up by the second appellate
Yes, Lord.
authority. However, the hearing has not yet commenced. Matter. Well, if that be so, we consider it appropriate, this court considers it appropriate to close the writ petition with the direction to the second appellate authority, namely respondent number.
Three would be approved.
Respondent number 3. 3.
3 and 4.
Who is the second appellate authority?
Lordship, 2. Lordship, that's the information commission.
The respondent number 2 to expeditiously hear and dispose of the matter within 4 weeks from today.
Lordship, kindly grant us slightly longer time. 'Cause the
6
hearing-
weeks.
Yes, Lordship.
6 weeks from today. Within the outer limit of July 8th,
Yes, Lordship.
2026. Needless to say, any such order that is passed, copies thereof will be served on the writ petition. Disposed.
Highly obliged, Lordship.
Yes.
My
Yes.
lord,
Yes.
the last occasion, your lordship gave me some opportunity to look into the matter. To look into this writ petition, my lord. So on the last occasion, your lordship was not inclined actually. So far, the petitioner has the grievance, only grievance is that she submitted her past choice, and despite of her grounds, so far incorporated in her representation, basically the parents are dependent on her. So both the parents actually, especially her mother, she is suffering from that osteoporosis. So osteoporosis for the movement and all. So she has to depend on others. So that is why the petitioner was looking for only 1 year deferment from the respondent authority, my lord. And prior to the issuance of the transfer order also, she submitted a representation, page 25, on 22nd January 2026. Apprising the respondent authority that she is having this sort of problems, and on the basis of that, she may be exempted from the annual
What
transfer.
orders were passed
Which order, Lordship?
on her application?
Lordship, the paragraph 4 and 5, Lordship. On the same grounds, she has
Page number.
that brief note. That
Brief.
prefix. That
That is a online.
Paragraph.
second, from bottom, third, second and third. That after issuance of so
Yes.
passing on the petitioner submitted online grievance dated so and so through employee corners seeking deferment of transfer for 1 year, mainly on personal grounds, including illness of parent, prospective marriage, and personal obligation. The grievance was duly considered by the competent authority and was regretted through online dated so and so. Observing that the posting had been issued on the basis of the choice exercised by the petitioner under annual transfer 2026 and that the request was devoid of merit. Petitioner had also sought similar retention during annual transfer 2025 on the grounds of marriage and care of aged parents. Upon consideration so and so, she was already excused from posting during annual transfer 2025. Petitioner has now repeated the same grounds during annual transfer 2026. And in the next paragraph, Lordship, first paragraph, that the allegation of malafide, arbitrariness, violation of so and so, constitutional and non-application of mine are wholly false, baseless, and denied. Petitioner has been accommodated against one of her own opted choice location, that is Kokrajhar, Assam, and this is the administrative and operational interest. She had given 3 choices. She is in Gauhati for 4 years. The other first 2 choices again in Gauhati. So that may not be possible. Now this is in Chalakati Kukrachar.
So the 1 year deferment was.
That was 2025 already
the grounds
considered.
of Basically,
Then
the
what?
parents are dependent actually. She is not posing the transfer. She is ready to get transferred, but only 1 year deferment, lordship. And
How is it going to solve your problems?
Be frank,
What are
Lordship,
you going to do with your parents within 1 year?
so some proper treatments on all she has to take care, and she can make some arrangement here. Within 1 year, she can make some arrangement.
even
And on the other hand, so that is why she purchased one flat also. The possession is not handed over today. She is going to settle these things, my lord. So that is why she was looking for the 1 year deferment.
one person again and again, this is not
And
possible.
it is
Lordship.
on these grounds of her parents.
So
Actually,
these are discipline forces. You can't just
yes, yes.
keep on asking for extension.
No, my lord, this is a 1 year deferment for the
Why?
last.
Under what provision are you entitled for 1 year deferment? Even you already
Yes, my lord, but the first choice that was not considered. Actually.
may not be one of the choices was considered.
And 10 choices are required to be submitted by the personnel, and that is the mandatory field to be
No,
submitted
did you
in the
submit?
online.
Did you give Poprajhar as one of your choices?
No, actually, what happened under compulsion, she has to submit it because it is a mandatory field to be submitted by the personnel through online process. So then only it is accepted, my lord. So the only genuine problems regarding her parents, ailing parents, my lord, but they are dependents actually. Basically, because of them, she has.
This kind of, you have to call out a right. Well, you have to be raise and decide on what kind of right you want. Otherwise, asking for a mercy petition for transfer.
The grounds shown by the petition.
On what grounds? 1 year. You've already been given 1 year. Poprajhari, it is nearby.
Yes,
4 hours.
good communication.
Good communication. Train,
That's
road.
true, my lord. But within 1 year, she was willing to settle her parents with some proper treatment.
That is not a ground, Mr. Counsel.
Yes, yes, my lord.
Why are you urging a ground on which there is no legal basis? Give us some legal basis that this is this mandate of the standing order, or this is what the act says, or these kind of considerations are done in respect of other candidates.
In the guidelines also only the choices that is mentioned. I have gone through. My lord, I may be allowed to file a fresh representation before the
You
PG,
find
my
it,
lord.
Third counsel for parties. The petitioner is aggrieved by the transfer order. Where is the transfer order?
Transfer order, your lordship will find at this 19.
Lordship,
Service order number 19/26, dated 30 March
By
2026.
his order, being Gauhati service order number 19/6, but by the petitioner, were shown to be transferred from
From IOC Gauhati
IOC Gauhati to
to
Poprajhar,
SBSS Salakati.
Salakati.
SBSS Salagati. Grievance of the petitioner is that she is the sole caregiver to her aged parents, who are also suffering from various ailments, and there is also a matrimonial prospect being explored by petitioner and her relatives, and it is for these reasons that the petitioner seeks a deferment of the transfer order for at least a year. The further ground is that the choices which she had submitted. What is her first choice?
First choice was OPS non-mati.
The first choice that she had submitted, OPS Mati. There are sufficient vacancies available, which, however, has not been considered, and instead she was transferred to SBSS Salakati under the district of Koprada. Under such circumstances, the petitioner is go to court on 13/5/2026. Petitioner was granted some opportunity for instructions, as also done a CGC appearing to the state. Then when the matter is listed, counsel for the petitioner renews this prayer with an additional submission that the petitioner be permitted to file a fresh representation before the authority is concerned, ventilating the grievances. Such prayer is not objected to.
Lordship, I'm objecting
You're objecting.
because, yes, Lordship, because if Lordship see page number 41, that is the document regarding her mother's illness, that says that routine testing is allowed once every 2 years. The testing frequency can be increased to 1 year. For the patient who have rapidly progressing.
The CDC, however, objects to submissions by that are considering the submissions made by the petitioner. This court is of the view that on humanitarian ground, the prayer made by the petitioner can be allowed. The petitioner is permitted to file a representation with all relevant documents before whom?
Before the DG, my lord.
Director General in Delhi.
Delhi, my lord.
That will take ages to get disposed of. File it before the Inspector General.
Yes, my lord. It can be done.
Before the Inspector General, CISF, NES headquarters, headquarters, respondent number 4. Within 3 working days from today. So the authorities concerned will thereafter dispose of the representation by speaking order and serve copies thereof on the petitioner. Stop. Consider the prayers made by the petitioner, then the transfer order, the appropriate orders be passed altering the transfer order. Let this representation be disposed of within.
Where are joint Lordship then?
No.
Yeah, it's not
Let it be disposed of within 2 weeks thereafter.
Status to be
Till the relief order was not issued.
The representation be disposed of by 10th of June. Till the next date fixed, the petitioner's release order shall not be issued.
much of.
Yes.
Petitioner like married in this case, so we want to withdraw this case.
Huh?
We want to withdraw this case.
Counsel for the petitioner on the instruction submits that the late petitioner does not wish to press the petition any further according to the same stand dismissed or withdrawn.
Much obligation.
MS S. Burwa for learned CDC. Okay. No, no, the last one. 11 to be.
In this given a claims of benefit of open the
Benefit of?
government of open the first thing.
Yes, Upendas.
Yes, Lordship. First they notice me go, I'll take instruction whether he
What
is in service.
instruction? You examined and pass orders. Verify, pass orders.
Lordship.
But counsel for parties dispose. It doesn't. After verification.
After verification.
Please, Your Lordship.
Yes.
This petition is for non-inclusion of the name of the second wife of the petitioner as nominee. The first wife died on, Your Lordship.
Petitioner is still serving.
No, he has retired. He is a pension holder. And his first wife died on 31/10/27. Thereafter, he got married. With
Second marriage.
second marriage.
Where is the death certificate?
That certificate is annexure 2. Page number 18 is the type copy. 19 is the original. Smriti Datta was his first wife. Thereafter, he got married with the for the second time.
What is her name?
Second wife, Your Lordship.
No, first wife.
Smriti Datta.
What is the name of the petitioner?
Petitioner is Dilip Datta. Dilip Kumar Datta, sorry.
Yes, Mr. Bhuai, get your instruction.
Lordship, very well, but at page 25, Your Lordship, there's already the letter from the Secretary Government, from the Secretary Government to the Accountant General for changing of nominee. Your
It was in the year 2022, Your Lordship.
Lordship. 4.
2004.
Oh, sorry. Oh, sorry, Your Lordship. That was 2004, it was a notification.
Pension and public revenue.
This one here.
So you have to alter this in the service book.
Yes, Your Lordship. And PPO.
You have received your pension.
Yes,
You are
I'm receiving
your
my pension.
Yes, Accountant General. Counsel for the petitioner submits that the name of the present wife of the writ petitioner has not been incorporated in the as a nominee of the writ petitioner for the purposes of family pension. If required, as may be required after the demise of the writ petitioner stop. Counsel for the petitioner submits that his first wife, Smriti Datta, late Smriti Datta, expired on
31/10/2017.
31/10/2017,
2017.
and he has submitted a death certificate to that effect from the appropriate authority. And the next of kin certificate is also obtained, showing the petitioner and his daughter as the next of kin of late Smriti Datta, the first wife. The writ petition stopped subsequently married. Stopped petitioner after his superannuation, he is a pension holder, receiving his pension. However, in spite of the representations, in spite of these facts being brought to the notice of the authorities, the name of the present wife of the petitioner is not being incorporated. Mr. Rara Gugoi, counsel appearing for the forest, and Mr. Rarpita Lunda, counsel for the accountant general of the private instructions. This matter again now. Mr. D. Bora, co-respondent number 1. Step office be furnished to the learned State Council and Departmental Council within 3 working days. List on 5th, 8th of May,
Deeply obliged.
8th of June, sorry,
Obliged.
8th of June.
Deeply.
Yes,
My lord, page 39, my lord, gratuity was released to me, my lord.
39.
39, my lord, page number 39. Gratuity amount of 7 lakhs, my lord, was released to me. There being dispute as to the amount of gratuity, my lord. I prefer an application form N before the controlling authority, which is the respondent number 3. Now, the respondent number 3, my lord, is yet to take a call on my issue, my lord. So my gratuity has not yet been determined, and I'm moving this court, my lord, under the provisions of the Payment of Gratuity Act. That's the extent of my prayers, that the respondent number 3 needs to exercise his powers and determine whether the gratuity is paid.
Is 4,90,000.
No, my lord, 7 lakhs, my lord, the first column, the first row,
Oh.
gratuity amount.
That has not been released.
No, 7 lakhs has been released, my lord, pursuant to an order of this honorable court in an earlier round of litigation. Now, 7 lakhs I'm disputing, my lord. My claim is that my amount should be in the range of 10 lakhs and more, my lord, based on the formula which has been given. So I approached the respondent number 3 because he's the controlling authority in the matter. Application N,
Third
my
Council for Parties issued notice for which Mr. CK appears in exception notice on behalf of
1, 2, and 3.
1, 2, and 3.
I am for 4, my lord.
Mr. Ardhor appears for respondent, pro forma respondent number 4.
My lord, was the employee of my
The grievance of the petitioner is not reporting a non-release of gratuity amount on the extent
Inaction.
of the claim made by the petitioner.
My lord.
So, since the respondent representative, which is the text of the respondent will complete their instructions and find silver.
my lord, the name of AGFC only showed the causes. It was not there, so I missed it.
You are only a pro forma, there is no claim.
No, my lord. But we have to file affidavit. Why that 7 lakh was paid, my lord, I will tell you. That was-
But he is not claiming against you.
Yes, my lord.
He made you pro forma.
But at the end of the day, we have to pay money.
Don't know, he is no claim against you.
This is not the appropriate forum for the quantum, my lord. The controlling authority is the quantum.
He is not seeking any prayers against you. He anticipated that you may object, therefore he is putting you as pro forma.
But my lord, at the end of the day, I have to pay the money, my lord. That is why I want to file payment.
You file it, we can't stop you from filing it.
My lord.
Wait,
Yes.
initially, my lord, the petitioner was placed under suspension on 22/12/2024, my lord. And that suspension has been extended from time to time. In fact, more than 1 year had passed. And that is when we approached your lordship, my lord. And this is what your lordship had to say, page 140, my lord. Page 140, my lord, paragraph 8. Your lordship had directed the authorities to, my lord, take a call on the representations so filed by me by treating it as an appeal under Rule 14. And this is the, my lord, the outcome. Page 145. Page 145, my lord, the operative portion is at the second paragraph from bottom, my lord. In fact, the line starting from the disciplinary authority. The disciplinary authority has hence decided that reinstatement at this stage may not be in the interest of public service, and therefore, my lord, the governor of Assam is pleased to extend the period of suspension for another 3 months. Same reasoning, my lord, which they have
What
been.
is the status of the disciplinary?
We have submitted our WS, but they are not, my lord, proceeding with that.
My lordship, we shall obtain the necessary instructions and file the affidavit, for which we require 4 weeks' time.
petitioner is scheduled to retire on 30/11/2026.
Right? Mr. Gupta.
Okay, that's on behalf of SK Talukdar Corporation Department.
This return. Status of the departmental proceedings initiated against the petition. Or we can direct them to close, dispose it of, directing them to expeditiously decide within 60 days.
That is up to date, but the problem is, my lord, this prolonged suspension is causing, my lord, a direct infringement of my right under Article 21. Because,
How?
my lord, the departmental departmental manual itself says that the sentence has to be, my lord, period of suspension has to be reduced to the barest minimum. Now, in my case, my lord, if your lordship kindly says the show cause notice at page 62, there is neither any list of witness. There is no witness against me.
Well, now it's saying the suspension.
Suspension.
Not the proceedings.
Not the proceedings. Only the suspension part.
Let it come
Let them
after,
file an affidavit in that case.
let it be after the return.
If possible, man, can I have a fixed date, man, since he's
After,
retiring?
after 2 weeks.
All right, DPS.
Petitioner working in Northern Regional Institute of Water Land Management, Tezpur, under Minister of Water Resource and Department of Jal Shakti, Government of India. They are recruited after 2020, 21, 23. They are not getting the new pension scheme benefit, though their salary has been deducted and the permanent retirement account has not been.
When were you appointed?
My lord,
When? What is your date of appointment?
2020, since 2020 till 2023. It is coming with effect from 01 month 2024. 2004, the new pension scheme was introduced. But they have deducted my salary. Last communication is lordship by department, page 32. Oh, sorry, 144, Annexure 32. Proposal for adoption of new pension scheme for new employer Neelam. I am directed to refer your letter so
All right, let us issue notice for the Bihar Council for parties issue. An exception notice on behalf of all of them.
All the respondents.
All the respondents, they will process the claim, the extra copy. Within a period of 1 week from today, list after the returnable date.
pendency of
Pendency of the writ petition will not be a bar to redress the grievances raised by the petition.
Regarding my family function, petitioner before lordship is a physically handicapped boy, my lord. And after his father's death, his mother was receiving family pension. His mother died, my lord. Now his stepmother, my lord. PPO order has been made in favor of the stepmother, that is his order number 7, my lord. So I am the physically handicapped, my lord. As per rule 140 COP, pension rule 1960, I mean.
Have you applied, represented before the authorities?
I have represented my lord, kindly see case 28, my lord, and duly received also by the authority. Case 28, my lord.
Yes, Accountant General. Who's for Accountant General? Accountant General. Accountant General. Wait for Accountant General. to
madam.
come. Yes, Accountant General, anybody? Please get your instructions in page number 28. Serve a copy on the Accountant General today. Please get your instructions on this page number 28. The Council for Accountant General will obtain instructions in respect of the representation filed by the Commissioner, page 28, the next so. The learned counsel for the petitioner will serve extra copies on all the councils representing the respondents. One copy. One copy. List this matter again on 8th of June. 8th of June.
Published. May please.
Yes.
No, this is a repetition, wherein challenge has been made. The impugned show cause notice as page 61. Under the impugned show cause notice has been issued containing allegation of contracting second marriage in the presence of the first marriage. That was the only solitary ground on which the show cause notice was issued.
Page number?
Page 62 is the relevant portion. Then, my lord, but the fact remains that prior to issuance of the show cause notice, the first marriage which was alleged to be contracted, that has been, my lord, nullified as a by virtue of a decree.
When?
That is dated 6/11/25. My lord will find Annexure 5, page 48. So, in view of that, when the marriage is not there, by virtue of a decree of competent court of law declaring the marriage to be void, then where is the question of issuing a show cause notice and not inquiring into that allegation?
When did you contract the second marriage?
A second marriage was solemnized 29/11/2023. Actually, my lord, the first marriage was in pursuance to the platonic.
Page, second marriage.
Second marriage, page 30, my lord.
So it is before nullifying.
No, marriage was before nullifying.
Then,
but the fact that, my lord, the first marriage, which has been alleged to be inquired into by the respondents, that marriage is no longer there. That marriage has been
no longer, but that marriage is become null and void with effect from 6/11.
Yes, marriage
25.
null and void from 6/11.
And you married, you got into the second marriage in 23.
Yes, my lord. First marriage also in 23, my lord. On 6/9/23.
Second marriage also in 23.
Second marriage.
Violates conduct rules.
No, what my submission is that can we take cognizance of a marriage and initiate an inquiry which has already been declared to be void by the Honorable Court?
At the relevant point in time.
6/11/25, the marriage no longer there.
6/11/25 is no longer there.
True, my lord.
But on 29/11/23 it was there.
If your lordships considers the show cause notice, the allegations which they wanted to inquire, my lord, tomorrow the inquiry, if conducted, what they will inquire? The allegation is that you have.
The allegation is that you have violated the conduct rules.
The allegation, my lord, will kindly have the show cause once.
Violation of 3(1).
Whereas it has been brought to the notice
Rule
of the
26.
Yes, Rule 26 has been alleged to be violated on the background of the fact believing that or considering that the first marriage still subsists. First two paragraph, your lordship will. First two paragraph.
But to say
yes
that the show cause notice cannot be issued.
No, what I am
because the day you entered into second marriage, your first marriage was nullified. That is not the case.
Lord, what I am on to is that, Lord, after the show cause notice, I have filed written statement of defense saying and disclosing the fact of the void declaration of a void marriage, first marriage to be void by the competent court of law. Despite that, they have appointed IOPO and they have proceeded to conduct the inquiry. Not what the question I am asking myself is that, my lord, what the inquiry officer will decide, my lord, because there is no subsisting as on date. What the inquiry officer will decide? My lord?
Inquiry
There is no-
officer will, were you a government servant on 29/11/23?
Yes, my lord.
You were. So you are required to follow the conduct rules.
You know,
You entered
that's
into a
true.
second marriage.
That's true. If if a marriage is declared, the first marriage,
They may have been informed later.
no, I am not on that, my lord. Subject to, my lord, your lordship's approval, the first marriage was on 8/9/23. By virtue of a decree of 6/11/25, the marriage has been declared to be void. It's void ab initio, my lord. The marriage is null, or it will go to the initial date of 8/9/23, my lord. From that date itself, it's void ab initio. Once the decree of annulment is
Where
there,
is the decree?
decree, my lord, will find page 48. And relevant portion, my lords will find page 53, para 7. Actually, my lord, there was no consummation of marriage, no cohabitation, nothing. The wife filed a petition title suit for declaration of a nullity, my lord. The first wife, she filed a petition and she has now married another person, happily settled, my lord. Page 53, down below, para 7 onwards.
Yes.
So section 5 lays down that any marriage solemnized under this shall be voidable and may be annulled by
Third counsel, H.K. Das, Indian counsel, assisted by Mr. D.K. Kapil. Petitioner, MSM Bhattacharya, and State Council, appearing for all.
yes.
Petitioner is aggrieved by the due show cause notice.
Lordship,
As well as the consequential orders.
Proceedings.
Lordship, if I,
Where is the show cause?
Show cause, my lord, will find page 61.
Proceedings initiated by the show cause notice dated 2nd of February 2026, to which the petitioner has also filed the statement of defense. Stop it. Counsel for the petitioner submits that the first marriage of the petitioner stood annulled by declaration, by decree of nullity, by order dated
6/11/25.
6/11/2025, entitled Suit Matrimonial number 20 of 2025 by the Court of District Judge Soraido, Sonari. Yes, stop. It is submitted that the second marriage, it is submitted that before the initiation of the departmental proceeding, the first marriage was declared to be null and void. It is therefore submitted that the proceedings as on date cannot take into consideration facts and circumstances contrary to the finding rendered by competent court of civil jurisdiction by judgment and decree and so and so. He therefore, for the court, challenging the initiation of the department of proceedings. Yes.
Lordship, after the show cause, the petitioner, he has filed his written statement. Then he also made an application for inspection of the documents. He inspected
Then when the next date of hearing, that means it was there, he just took a time, Lordship, page 78 may kindly be perused, because he was on official duty, so he could not be present, Lordship. So my humble submission is that admittedly, Lordship, on the day of the second marriage, there was a valid first marriage, Lordship. And being a government servant, he has committed this is a misconduct on his part, Lordship. So this is later stage, Lordship, when nullity part.
Misconduct till the day before the judgment was passed.
Lordship.
The day the judgment was passed is become
Yes,
null.
this is, Lordship. This is there.
But
on the day when, so being a government servant, Lordship, there, as this is something discipline and all these things are there, Lordship. So my humble submission is that, Lordship, the inquiry may kindly be conducted and may into a logical conclusion, Lordship. My humble submission is this.
what is that logical conclusion?
What is the conclusion? Because I am not the inquiry officer. It is up to the inquiry officer.
Therefore, you'll have to satisfy the court that notwithstanding the declaration of the marriage, first marriage being null and void, there still exists a parameter
Please.
which can be looked into effectively and decided by the authorities. You are now trying to look into an aspect which is not in existence. It is null and void. The slate is wiped clean. It is as if he has no marriage.
Lordship, who knows? This may also the outcome of the inquiry also.
So we don't know.
Yes,
So-
Lordship, that's what, Lordship.
So therefore,
So my humble submission is that
if this is the outcome of the inquiry, then why the inquiry in the first place? Inquiry is to make this is to inquire into the facts and circumstances which will prima facie amount to the
violation.
imposition of penalty. Anyway, respondent counsel will complete her instruction and time and say. Meanwhile, you have only
My lord,
there is no date for appearances.
but 25, 23.
Today is the date for
today is
appearance,
the date
Lordship.
fixed for.
At 12 noon.
So that's why, my lord, I made a mention on Monday, my lord. Asking the praying before your lordship. I have an interim prayer, my lord.
Today,
page-
12 noon,
Page
Lordship.
26, my lord.
What is
Well,
that?
My lord, further proceedings of the departmental, otherwise it will. Other proceedings may, my lord, because it will be a futile exercise, my lord, in my humble submission, my lord. The point of law has been raised, my lord, that has to be decided. Otherwise, my lord, I will suffer injustice, my lord.
Considering the submissions made, question of law, which is regarding the futility of the permanent proceedings, get the proceedings to reinstate the next date of listing.
Fine.
And the respondents will apprise the court. Respondents will address the court on the question of law raised before this court by the petitioner based on 12th of June.
12, 6,
The
Lordship.
interim orders passed today will continue in the next date of listing.
Lordship.
Deeply obliged. Highly obliged.
And the here is application to petitioner has filed challenge the include order notification dated 9.
You're questioning a transfer order.
Regarding yes, my lord. At page 16, my lord. She was working as.
Did you file a representation?
Yes, my lord.
Where is that?
First representation at Annexure B, my lord, page 19.
Page 19.
19, my lord.
What happened?
Then thereafter, my lord, it was not considered. So since she was transferred on my lord, election purpose, so she joined on 15th, my lord. Thereafter, my lord, her mother made a representation, page annexure D, page 22, my lord. And medical certificate is, my lord, annex, my lord, page 24. Your lordship may kindly peruse, my lord.
The medical certificate says that she needs constant medical care.
Yeah, because, my lord,
It does
she's
not
8
reflect
years.
that you are the only caregiver. Are you the only caregiver?
Yes, my lord. Only mother and daughter. Nobody is there in the family, my lord.
If
So,
you file another representation, take a call.
Lordship.
Third counsel for parties, the petitioner is aggrieved. Where is the transfer order?
Transfer order annexure A, page 16, my lord.
Agreed by the infringing order.
In her
of transfer.
representation, she stated she is the only one, my lord, to take care of her mother, my lord, page 19. My lord.
Dated 9/3/2026, whereby the petitioner was transferred from PC division, her present place of posting. Where is PC division?
My lord, it is Murigaon, my lord.
Huh?
My lord, she was, yes, my lord, PC, my lord, PC division, my lord, the transformation and, my lord, transformation and development, planning service, my lord.
Where is she posted?
She is posted as SDO IC at Morigaon, my lord. At page 16, my lord.
Petitioner was
Serial
posted
number
as
3, my lord.
in the PC division in the during her service as assistant director, the Assam Planning Service of Transformation and Development Department. And by the order of transfer dated 9/3/2026, she was posted as SDO in charge, the office of the DC Morigaon. So, submission of the counsel for the petitioner that she is the only caregiver to her 80-year-old mother who is under constant medical supervision and care.
One more submission, my lord. Her original place of post is still lying vacant, and she is receiving her salary.
You are joined in Morigaon.
Morigaon, my lord.
Oh.
But her original, my post is also still lying vacant, and she is receiving a salary from my lord his school, from her original post, my lord.
Is the submission. This is in terms of election duty.
Yes, my lord.
It is the submission of the petitioner that this transfer was effected because Kamrup Metro is her home district, and in view of the ensuing assembly election, she was transferred out. So, however, the elections are over and the results were declared, she is required to be transferred back to her original place of posting in view of the fact that her mother requires constant care, medical care and supervision as she's 80 years old. And she's 72 or 80 years.
80 years old.
Huh?
80
Doctor
years
says
old.
72.
No, my lord. This is type 2, my lord, type 2 diabetes. It is typed as 72 diabetes. Her age is 80 years, page 24,
80
my lord.
years. The mother is also represented to the authorities and which have not been redressed, and response was forthcoming petition from the responding authorities. Under such circumstances, the petitioner before this court, Para MS Sharma, State Council, submits that she would like to complete her instructions in the matter, as also the council appearing for. Why is the finance a party?
Because there's a question of
As
salary is
standing
also there,
counsel
my
for
lord.
finance and accounting. Why accountant general?
Because the question of salary is there.
Salary, they're not concerned. They're concerned with pensions.
Only, yes.
Are you retiring now?
No, my lord. After 3 years left.
respondent number as also the council for accounting member. So, considering the limited prayers, the writ petition is court considering it appropriate to close this writ petition, giving liberty to the petitioner to file detailed representation before whom? Before which authority?
Before the, my lord, the senior most, before the respondent number 2, my lord.
Respondent number 2. And whereupon respondent 2 will consider the grievance and the claims made by the petitioner and pass appropriate orders thereon. Let this representation be filed within 1 week from today, and the respondent number 2 will dispose of the same within a further period of 3 weeks thereafter. Petition accordingly stands disposed.
Obliged.
Yes.
I'm selling a transfer order, madam.
Yes.
I'm based in Borpeta. They are sending me to Karnataka. My ground is, my lord, my wife is suffering from autoimmune disease, my lord, of the kidney, lupus.
What is this?
Lordship will get this at page 26.
No, what are these bunch of papers?
Lordship, on last time, Lordship asked me to take instruction. And regarding Lordship, why his posting cannot be staged, Lordship, or he cannot be retained here. And apart from that, Lordship, one more question query was there, Lordship, that whether in where he has been posted, whether there is sufficient medical facilities are available or not. That, Lordship, that is not there, Lordship. Regarding that, I have the instruction, Lordship. Regarding that, because he has been transferred to Karnataka, his main.
You bring it on record, file your affidavit.
Lordship.
Bring it on record. In deference to the earlier order, from CGC has received certain instructions. The court permits him to bring it on record by filing an affidavit. How soon can you bring it? Weeks. Under such circumstances, let notice issue return every 2 weeks. Let the affidavit be. Let the respondents endeavor to file their affidavit as permitted. List this matter again on 8th of June.
Till there was no movement.
On 12 Lordship, can you
Huh?
12 Lordship.
Huh?
On 12 Lordship.
12th of June. Be listed on 12th of June till the next date of listing. No movement orders be issued to the writ petition.
Give them it.
The respect of the transfer order.
This case, Malad, pertains to Malad non-acceptance of OBC NCL certificate. It is a covered case, Malad, kind of page 116, Malad. Page number. OBC NCL certificate issued within 180 days.
What do you say?
Item number 4.
4, same order.
Same.
He is entitled.
Lordship.
Only one petitioner.
One.
All right. Item number, what was the other item? 4. Plus, that order to us here. Page number 116. Third, councilable parties disposed.
All right.
May be also. Look, this is a matter pertaining to transfer of the petitioner from Gauhati to Chandigarh. Look, the petitioner was initially appointed in the year 2019, and he was posted from Mumbai to Gauhati on 7/7/2021. and by now he has completed around 5 years of service. The transfer policy says, if I just take your lordships, one of the transfer policy at page 20, my lord, it provides that they'll get an incentive of posting of their choice after this hard tenure at notice. Page 20, my lord, will kindly have. As per the Government of India guideline, our bank is extending following incentive to the officers posted transferred to the northeastern region. Those officers who are transferred by the bank to these places, they will be given posting at a place of their choice out of 3 places after completion of their tenure in northeastern states. This is one. Then this is a circular dated 5/3/2015. Then their transfer policy, it starts from, my lord, page 22, dated 4/1/25. The said transfer policy also provides page 29, my lord. Firstly, para 6.5 of page 29, it provides that at present, Northeastern region and Kashmir Valley are designated as difficult areas. However, the above definition may be modified from time to time. Then 6.5.2, my lord. As an exception to para 6.2 above, request for retransfer submitted by the officer posted at Northeastern region on transfer from other parts of the country may be considered as per the choice given by him, her, after completion.
Where is the impugned order?
Impugned order, my lord, will find it at page 19, my lord.
19.
Yes, it was followed. It was followed by the order at page 18. It is a mail, my lord. There is a portal, Starlight portal. There a mail came, that is page 18. It is hereby inform you that the transfer order has been issued in your name on administrative ground. You are requested to log in at Starlight. When I log in, this page 19 comes, my lord, wherein it has been intimated that I am transferred to Chandigarh. Lord, I am entitled for choice posting after rendering 5 years of service in Northeastern state.
Have you given your choices?
Lord, the problem is that not to speak of giving me choice posting, they did not give me option also.
Under what provision you want choice posting?
Lord, this para, first of all, the circular at page 20, which provides that as an incentive, there will be choice posting to the persons who have completed their tenure in Northeastern states. Page 20, para A. Then their transfer policy also, page 29, para 6.5.2, very specifically provides, as an exception to para 6.2 above, request for retransfer submitted by the officer posted at Northeastern region on transfer from other parts of the country may be considered as per the choice given by him. After completion of 2 years of country, I am entitled for choice posting after completion of 2 years. I completed 5 years. Despite that, they did not give me the option, did not allow me to give the option, and they transferred immediately to Chandigarh. You know, my son is, I'm getting treatment of my son. My son is suffering from several ailments, Milord. I'm getting the treatment from a doctor here in itself, Milord. Those are the additional factors, but their own violation.
You get better treatment in Chandigarh.
No, that's fine. That's an additional aspect of the matter, Milord, regarding the hardship. But on the face of the record, it's apparently their violation, Milord.
But this is only a guideline.
That's true, Milord.
Does it give you the enforceable right?
So that's true. That's absolutely correct. There is no quarrel with that proposition of law. But the fact remains.
Merely because it is stated in the policy, does it mean that you are entitled to be granted overriding administrative expenses?
Lordship is absolutely correct. But if there is a guideline, are you not required to follow your own guideline?
Can you? So The guidelines will give you, because all the authorities are con.
Well, there is a judgment of the Gauhati High Court, my lord. I just, I'll just place it, my lord. But the thing is that it says you cannot mere exceed and violate your own guideline, my lord. It's true that it's not statutory or it's not. There are judgment, my lords. Lot many judgments, Bank of India and other judgments are there. Shilpa Day.
Most of the judgments are that your guidelines don't give you an enforceable right.
No, that is with regard to right. But the aspect whether a policy of your own, an incentive scheme of your own, you have circulated that we will give a choice posting and you will violate and did not give me option. I am not on the question that I have opted for 3, they have not given me anyone. Here the case is, they did not give me
that accept that argument. You'll have to prima facie accept that this gives you some
the right limited
protection or right.
The limited right I am having from the circular and the policy is the right of consideration, my lord, under Article 16. If my right of consideration is denied and they don't give me the option, then, my lord, it's prima facie violation, my lord.
Heard Mr.
B.
Petitioner is agreed by his transfer to Chandigarh. What is ARB?
ARB.
Chandigarh ARB.
This is the branch name, my lord, the zone name, my lord. ARB zone.
Is present serving as what?
As, my lord, Manager Law Scale 2 within bracket.
Manager Law Scale 2.
At Gauhati Zonal Office.
The Bank of India, Gauhati Zonal Office. Stock Council submits that in terms of the circular issued by the Human Resource Department of the Bank of India, officers who were transferred by the bank in the Northeast are entitled to give posting, choice posting for 3 places after completion of the review. So, this is further submission that respect of transfer, in respect of re-transfer to zone or hometown, the consideration of the choice posting is also reflected in clause 6.5.2 of the same transfer policy. Council would therefore submits that no option was given, not to talk about the consideration of his choice of posting, and in view of the absence of any option being granted to the petitioner, he was not in a position to give his choice of posting. So therefore, the same violating of the transfer policy in order of transfer is contrary to the circular and therefore calls for interference by this court. Council with the petitioner therefore submits that the transfer order the payment set aside by the court and giving dependence user petition adequate protection be granted. The council to the parties, petitioner and upon perusal of the petition, get notice issue, returnable forms, steps on all the respondents by speed post.
Yes.
1 week from today.
Yes.
Let the matter be listed again on 22nd of June, 3 weeks. They return in 3 weeks. 19th of June.
Fine.
Issue notice on the interim grade, returnable on the same date.
Some protection, my lord. He, till date, he is there, my lord. But
Till
my
the
statement,
next date of listing, the transfer order shall not be given effect so far as the retribution is concerned.
my deeply offended. Hello.
After 3 weeks, but in the meantime, there is a the first step. I think they feel more review regarding the order which is to be identified.
Proposal, not yet filed.
No, not yet filed, but there is also going on.
Why should we defer it?
Well, lots of only 3 weeks time, and in the meantime, not whether
We can grant you time for compliance of the order. We can't say we'll grant you time so
no,
that you can file an appeal.
that is my submission. But lots will proceed after 3 weeks. In the meantime, let's say
2 weeks. We'll give you 2 weeks.
Right.
Comply with the order.
Date may be given.
Yes. Council will be respondent. Is GMC.
GMC.
Prays for further 2 weeks to complete his instructions regarding the compliance with the petition. Orders of the past in the petition. MS.
A. Pujari.
A.
A. Pujari.
A. Pujari learner. Council submits that matter be listed on a fixed date. Considering the submissions, list again on 12th of June.
Much.
Okay.
Yes.
I quoted 19 to 20. The next one is 13 to 19. Then 5% also pays 18 also.
Yes, complied.
This is the latest instruction.
Not complied.
No, we are seeking for some further time.
Why? Why further time?
So far as the petitioner is concerned, part has been verified and his name has been now kept in the list of eligible candidates. But now it will be placed before the government, now government has been formed. So they will finally issue the approval announcement. That is it. Only that part. Otherwise, he has been considered to be there.
What is the direction of the court?
Yes.
The learned counsel, Mr. B. Gugoi, appearing for the respondent, was placed before the court. A communication received from the Additional Secretary, Department of Finance, EC-2, that the case of the petitioner has been received, proposal has been received from the Administrative Department for granting the minimum of pay scale in compliance with the court's order dated 24/2/2025, passed in the PPC 303 of 25. The name of the petitioner is included in the final list for grant of the minimum scale of pay. However, in view of the new government having sworn in, new government in place, some further time while complete all the formalities for release of on scale of pay as per the direction which the council for the respondent submits that 3 weeks further time be granted, by which time he submits that there is every likelihood of the order being complied with, the benefit being granted to the requisitions. Is this matter again on 15th of June? Welcome.
That actually, kindly period the last order 7-5.
Which order?
7-5.
Yes.
Submitted that.
Yes, where is Mr. Roy? How, when do you propose to release?
It is a forest man who will have to make the payment.
You get your instructions, we'll keeping it on 15th of June. Mr. Gogoi?
We have till 15th June because funds are not there. We ask for fund, additional funds. It will run to 21 lakhs.
So funds are not there is not his problem.
We understand, madam. So we are arranging, madam. We are placing fund demands. And that leave
He
period.
submitted that the entitlement of the petitioner has been determined to be at 21 lakhs. However, the funds not being available, the state government submits, council for the state respondent submits it further time being granted and to them to complete the instructions as agreed to this matter again on 15th of June.
15th. All right.
Is your lordship.
Yes.
Contempt petition is filed challenging the non-compliance of your lordship's order. This is 14/5/24 lordship. The direction was, may I take your lordship to para 7?
Yes, no, what is the last order?
On the last occasion, previous occasion, the other side had sought time to file the come back with it.
Yes, what?
Lordship, till that we have not received the required documents, your lordship. In the department also, no documents are available. We are written to the petitioner 2 times, your lordship, but not received the required documents.
What documents?
Lordship, that is the original appointment letter of first entry in the government service, appointment letter for joining in the flood control department, joining report, age proof, and qualification certificate. Only the requirement of these certificates are, these documents are very much necessary to reconstruct the service book, your lordship.
Why don't you furnish the
Declare
copies
your
that are
lordship.
available with you?
Lordship will take note of para 6 of your lordship's order at page 14. Where your lordship had recorded the peculiar case of the petitioner is that he had rendered services at a time when the capital of the state was in Shillong, and unfortunately during the transit of records from Shillong to Dispur in 1974, certain official records are stated to have been misplaced by the department, and consequently no records in respect of the petitioner or his services are found available in the Water Resource Department. Only records available in respect of the petitioner as admitted by the department are the records with regard to the drawal of salary as NDA for the period 1970 to February 82. The documents stated to have been submitted by the petitioner are also not specifically denied, save and except that the certificate stated to have been issued by the superintending engineer upon due verification was not found to be authentic.
But there must be some copies with you. Why don't you give them copies so that it will expedite
I did
reconstruction?
inquire, but
Ah.
the petitioner is not well. His wife attended to the phone call. She told me that no records are available.
How can how can we help you? Department has said no records. You say no records. From where will the records come? You have to give some connection to the records, some communication, something to say. Can't say that there are no records, so we'll have to recall this order, if that be so. Otherwise, the department has, we had already recorded the department saying that there are no records. So giving them a direction is okay, but they must be having some access to some document to reconstruct the records, isn't it? So you get fresh instructions from your client and find out at least something to begin with. Appointment orders, transfer orders, promotion orders, something to begin with. So which will have a reference to the file numbers, right? The records necessary for reconstruction of the service book are not available. The counsel for the petitioner submits that as per instructions, the petitioner does not have any records available. The counsel representing the respondents has also expressed her difficulty in reconstructing the records as no documents are available. So under such circumstances, we permit the counsel for the petitioner to obtain fresh instructions from the contempt petitioner for any document relating to this service, which will aid reconstruction of the various documents, reconstruction of the service book, respect of the petitioner, in terms of the directions of the order dated, passed in directions of the order dated so and so, passed in WPC so and so. List.
Will adjourn it for 4 weeks.
4 weeks. They start to 4 weeks.
Okay.
There my lord, as in item 25. On 15th, my lord, regarding my lord minimum of pay scale. All
Yes,
this is
madam.
considered. Get that.
Mr. B. Goy, additional agent for the state, appearing for the respondents, submits that the matter be also listed on 15th of May, by which time instructions. Mr. B. Hazarika,
Representing
respond, appears
I therefore 5 men.
for respondent number 1, Mr. Goy, respondent number 5. MS. Stakuria, the council appears for the petitioner. It's on 15th of June.
May I please your lordship. My lord, office note, my lord, dated 27th to 26th, my lord. The my lord,
AD card on 14576, not received.
my lord, in the meantime, my lord.
5 my lord, I may pay.
5 you're appearing.
9.
For 4. Then
I'm appearing to respond.
3. As per office note 27/4/2026, unserved notice on respondent 2 with the endorsement with the court's addressing left. Part yes, court's closed proceed. Petitioner will take fresh steps on the correct address of respondent number 2. Office note also reflects a AD card or unserved notice has not been received back on respondent number 1, 4, 5, 6, and 7. So, however, Mr. Kunsoikia appears today before the court on behalf of respondent 5. Mr. A.K. Ghosh for 4. Respondent 4. Mr. Cholia has already appeared. Respondent 3. Stop. Service report for respondent number 1 and 1, 6, and 7. Please again after 4 weeks. Meanwhile, the council representing the respondents 3, 4, and 5 are permitted to file their counter affidavit if so advised.
Application for including Commissioner and Secretary, Governor of Assam. A bill was passed in the year 2020 for pensionary benefit to the retired executive members and
We should notice today.
Because the government has said in their affidavit, the matter is pending before the governor, so therefore they are unable to process. Paragraph.
Let us issue a notice making it returnable after 1 week or so. Heard Mr. B. Das. Assisted by Mr. Jelota, applicant. So notice returnable 2 weeks. Steps. Are you accepting notice?
Your Lordship, I don't have a copy of the IA.
I'll give it.
That's right.
I have got number 1, 2, and 3 or not.
Ms. R. Data, English for respondent 1, 2, and 3. Mr. D. Bora, respondent number 4 and 5. And the finance, anyone for finance?
If finance.
Say notable for respondent number 6. So the extra copy will be furnished within 3 working days. Respondents may file their objections if in the meantime, is this matter immediately after the returnable date on on 8th of June.
For the Commissioner and Secretary, Governor of Assam, he will accept it.
I can accept, but
I'll have to get he will accept.
But they're not made a party as yet.
As a government representative.
but that notice be.
So therefore, we are issuing notice. If they have any objection, that they're necessary party, not
I'll have to
necessary.
hand over the copy.
But they're not arrayed as a party as on date.
You'll not should be errate also because in government affidavit says bill is pending. By Karbi Alam Council, they are getting it. BTC, they are getting it. But NCL, the bill is pending.
All right, give them a copy, extra copy. Mr. D. Bora also accepts notice on behalf of the secretary to the governor.
Commissioner and Secretary,
Commissioner and secretary. Governor. The respondent is proposed to be a party respondent in WPC number so and so.
Wait, please, Your Lordship. File this interlocutory application for amending the address of the inquiry officer, Your Lordship.
Inquiry officer.
Inquiry officer.
Who is the inquiry officer?
Inquiry officer, he was the additional
Respondent
superintendent.
4.
Respondent number 4. He was the additional superintendent of police, Your Lordship. Now he is working as Deputy Commissioner of Police, Kotopur.
His IA has been filed seeking amendment of the address of the respondent number 4 in WPC 2425 of 2024. Stop. The said petition in the course title. The respondent 4 address which was reflected according to the petitioner was wrongly shown due to site. So it is therefore submitted that by this IA, the correct address has been obtained and permission is sought for making necessary changes in the address of respondent number 4 as reflected in the course title. Any objections from the respondents?
No objection.
The Sharma appears for the respondents opposite party 1, 2, 3, 4. Since there is no objection by the opposite party, this IA stands allowed. Petitioner is permitted to file amended course title reflecting the correct address of respondent number 4. Stop. The respondent number 4. Correct address of the respondent number 4, namely para 4 of the page 4 addresses, sub para. The amended course title be filed within 1 week from today. Stop. The registry will thereafter make necessary changes after the amended course title is filed. In connection with WPC 2425, IA accordingly stands allowed disposed of. The writ petition is right in view of the order passed today in WPC so and so. The petitioner is permitted to file amended course title reflecting the correct address of the respondent number 4 as state after the amended course title is filed into the registry and necessary changes that were made by the registry. It's according. Very good.
The matter relates to rejection of the candidature of the petitioner in the matter of compassionate appointment. What happened in this case, my lord?
Implement. You are seeking implement in the IA.
Implement in IA.
Any objection?
Lordship, Commissioner, Secretary, Government of the Personnel Department. Lordship, even then also, the issue involved here is Lordship. Lordship may implement, I don't have any objection.
No,
Lordship.
IA. The
IA, yes, Lordship.
This application is filed by the applicant seeking implement of the Commissioner and Secretary, Government of Assam, Personnel Department. It submitted that the same respondent is the necessary party in connection with WPC 5428 of 20.
Another IA. There is another IA, Lordship. Another IA is there.
IA 1431. Accordingly, he extends the law. So and so stands included as respondent number 5.
Yes.
In WPC number so and so, and it was title to be 5. Then in the writ petition is right in view of the order passed so and so. Amended course title is permitted to be 5. So and so is arrayed as a respondent for 5. And to be listed after filing the amended course title. IA 1431 stands allowed disposed. What is the other one?
For one regarding challenging the notification.
Challenging the notification.
Issued by the respondent number 5.
You are filing an IA.
IA also.
Madam, there will be difficulty because madam, the entire structure of the writ petition will change. Even the prayer.
But that is material bearing with the issue involved.
But if you want to challenge, you file a separate
Yes,
petition.
Lord.
Why
This is
filing
that's
an
why
IA?
we have objection.
No. My lord, one thing is that this notification has been already set aside by this honorable, by a coordinate bench of this honorable court. That's why
It has not been set aside.
Which notification?
the notification which is annexed, sorry, IA number
18,920.
1430.
Yes, page number
13. One,
Let's show how the set assignment is still.
Please enclose some order.
My lord, that is what, my lord, go through the order, my lord, where it is set aside.
18924.
yes,
My lord, where it is set aside, my lord.
Which order are you referring?
the order of this coordinate bench of this honorable lordship will find at page, last page, 88 onwards.
It's not set aside. What are you
Lordship,
saying?
this one, Abdul Qadir.
So far as my understanding, I have gone through
No,
it.
your understanding also, if that is your understanding, then we are sorry. You have got say.
That may be
It can't
considered
be-
after implement or after
How can you interpret an order of the court as per your liking? Show me the paragraph on where for a notification to be set aside, there must be clear finding and direction.
Lordship will kindly go to para 9 of the
para
order, 9 Roman.
Yes.
All the applications for compassionate appointments submitted by the petitioners shall be considered and disposed of by the concerned DLC SLC on merit by taking into consideration the various guidelines prior to 1417 laid down by the state government for compassionate appointment and the judgments of the Honorable Supreme Court and the High Court, consequently the rejection of all compassionate appointments by the DLC SLC which have been put to challenge and are pending in the Gauhati High Court as on T420 2024 for 5 hours set aside. And the entire process for considering the various applications for compassionate appointments, the decision to be taken on each and every case.
You are seeking amendment. What are you seeking? By this
First of all, my challenge is to implement this officer commissioner and secretary.
That we have done.
That's the lordship agreed. And thereafter, after implement, this IA may be considered. In the light of this judgment, this this petition may kindly be disposed of. And there are so many other orders, other connected orders also. Because this honorable court in during the course of proceedings of the main writ petition directed to reach this matter before the bench wherein.
All right, we'll keep this IA along with the writ petition. We are
Yes,
not issuing any orders.
Yes.
Zion listed along with WPC number. What is the number?
The WPC number 5428.
5428.
Or 24
After 3 weeks.
after filing the amended.
Not amended. We are not issuing any notice. We want to dismiss your IA as well as the writ petition. We are just not doing it today. We are giving you an opportunity to rethink and address the court.
If you apply.
Yes.
I have got. The secretary.
Any objection? Heard counsel for Parkinson. Amended court side meeting is like I dispose the writ petition, you the orders. In period as responding on so certain side. Dispose. Yes.
Matter will listed along with the series.
There
are some other pending matters listed along with that.
It is submitted that there are other similar matters pending before the court. Counsel for the petitioner submits that these matters be listed along with
2301
WPC 2301 2020
24.
24. Prayer is made is not objected to by the counsel of the respondent. List accordingly.
Sir, matter, they can have two lots. Much
Affidavit is being filed today, my lord. We have received it. We have given it.
There, have you served a copy?
I will serve it once it is ready.
Serve the affidavit is fine. Go through it.
I have not received any.
He says he'll serve you.
Today,
It is submitted by the Standing Council Forest that the affidavit filed on behalf of the Forest Department. Course of the day that we saw, let the matter be listed after 2 weeks.
No, no, it may be fixed also. Yeah. 28
Huh?
28.
What if you want to file a reply affidavit? When do you want it?
28.
28.
Yes, ma'am.
What is so special about 28? Eleventh June. It's on 11.
Yes, no affidavit has been filed by the department.
My lord, this is not about affidavit, my lord. My lord, this petitioner, her husband actually was, my lord, was not in service from 8/8/78 to 31/3/98. So, my lord, these long years, now we want to give them, at least department is trying to give, my lord, the pension, family pension, my lord. So, for this, my lord, under FR 18, we need to, my lord, take approval from the governor, my lord, these long years. So, we have sent it, my lord, it will take some time, my lord. Let them wait, my lord, they have waited.
Why don't you bring it by way of an affidavit or some communication, something to say?
My lord, I have the communication, my lord, that I can bring on record, my lord. But, my lord, actually, I was trying to get the confirmation whether governor, my lord, give the consent or not, my lord. It's a 20 years gap.
20 years after his retirement, you did not release his pension.
Did not approach also, my lord.
Why should he approach?
Page 18, my lord.
He is not required to approach. You are supposed to send these papers forward.
Forwarded to the AG, my lord. AG returned, my lord, stating that, my lord, some debt absent period to be regularized.
My lord,
But
my lord, we have forwarded 20 years, my lord. He was.
Pension is, see, before he retires, you know who are your employees who are going on superannuation. There is a procedure, there are clear rules under the pension that these papers should be forwarded. You can't settle the responsibility on him that he did not approach.
No, my lord. That is so, my lord, that is what, my lord. It's a not a regular case.
How much time do you want?
My lord, let it come for 4 weeks, my lord. Because
4 weeks is too much.
my lord, we have moved. Now
when have you moved? Has it actually moved out of your office?
Yes, my lord. I have a letter to this.
Sent to whom?
Sent to the director, sent to government, my lord. And from there, my telephonic.
When is it going from the governor's office? When is it going to take off from the governor's office?
Well, that part I will take instruction.
That is the instruction required. You get it next week, Monday.
Well.
List on Monday, enabling the state council.
Monday, let me Wednesday.
Wednesday. It 28 তারিখ বন্ধ আছে কিন্তু শিফট হয়েছে নাকি? If it is a working day, we are fixing it on 27. Otherwise, it was scheduled to be a holiday.
Or else Thursday also, my lord, can fix it, my lord.
So, because if it is not a working day, then Thursday is the holiday.
Oh, my lord, I understand.
Or we have it on 29th.
My lord, that will be safer, my lord.
খবর লক্ষ্য ট্রেনিং Yes. Make me.
Non-payment of my lord, pensionary benefit.
Non-payment of
Pensionary benefit.
pensionary benefit.
My lord. He retired on my lord, 31st of
Yes.
December 2007, my lord.
You are aware of this circular, na? Recent. Very recent.
My lord.
Yeah. 18.5.
Yes, my lord. Yes, my lord.
You give us the names of the officers who are responsible for the delay. We'll identify and direct proceedings against them.
My lord, now the officer they have to pay 250 per day. They are in the.
So give us the names.
My lord.
Why this delay?
My lord, in this we are yet to file the affidavit. My lord,
File your affidavit within 2 weeks.
my lord.
Complete pleadings. Mr. K.U. Ahmed appears for the petitioner. Mr. R. Dhol appears for the respondent. PWD. MSA D. Bora for respondent number 2. MS B. Sharma appears for B. Sharma. You are appearing for B. Sharma. And accountant who's for finance.
Accountant general. Actually, my lord, from page 56,
Respondent 4 and 7.
it turns out that the AG has, because of that Sanchita 20 years, 6 years reduction they have done. We have done our part. We have sent it to the AG.
Who is for finance department?
Here, my lord.
Respondent 4 and 7 for Mr. Chalia. The respondents will complete their instructions and file necessary affidavit within 3 weeks. List accordingly. We are giving you 3 weeks time to file affidavits. All the respondents.
This is regarding gratuity, Lordship.
Gratuity.
Lordship. Our file
Who
was,
is the authority required to pay?
Lordship, her file was forwarded also by Assistant Chief Engineer, 27, page number 27.
Yes, Mr. Dhor.
It's his.
My lord.
Instructions
My lord, these instructions I
on
don't have.
29th.
29th. 29th, my lord. 29th.
List on 29th, enabling the standing council to obtain instructions. R. Dhor, standing council, PWD to obtain instructions. MS A. Sharma. For B. Sharma.
People.
So as per the last order, I was going to file an affidavit in opposition, Lordship, to bring on.
What has happened? You filed it.
No, Lordship, it has been prepared, Lordship. Only thing is that the signing is not been done by the
You
author.
do it by Friday. Let the affidavit proposed to be filed by the respondent be filed positively by 22nd. The copies be served on the writ petitioner, thereafter the matter be listed on 5th of June, by which date the petitioners may file their rejoinders, if any.
Possible. Okay.
Yes.
Even of Miller, leave encashment.
Leave encashment. Instructions.
Lots of instruction I have received. If lots of permits, lots of I can file my affidavit. I'm not taking much time. Lots of 1 week time will be done.
Mr. A.K. Hussain for the petitioner, Mr. D. Nayak, additional AD appearing with the respondent, submits that the instructions have been received. He would like to bring it on record within 2 weeks. Let the affidavit be filed within 2 weeks. and the respondent petitioner may file their counter affidavit, rejoinder affidavit within a week thereafter. List on 15th of June. Mr. D. Bora for
3 and 6.
3 and 6. Mr. B. Sharma for 4. Yes. And yes.
The last order of the government was directed to furnish instruction as to why the petitioner has not been allowed to join. Paragraph 7 on.
Yes, why have you not allowed him to join?
My lord, that part, my lord, so far as the joining part is concerned, filed on affidavit, but in the meantime, my lord, the speaking order has been passed. And my lord, I will serve a copy to the petitioner also against all the 3.
They're dismissed.
They have been now dismissed, my lord, considering their reply. All facts have been given. And now only remains, my lord, from the date of the earlier order whereby the termination was interfered with, till this particular date, whether they should get the salary or not. That we will file an affidavit, lordship will consider, my lord, keeping the matter. There was no advertisement, nothing, my lord. That they can, of course, they can challenge. I will serve a copy of the speaking order.
Of course, I can challenge, but the facts and attending circumstances, lordship has seen has been.
So
filed.
now the claim would be only monetary
Yes,
financial
that remains, my lord.
That Malad is another Malad. Obviously, I can claim that, but you know, when I have filed this petition, when the so-called notice was issued, and when this termination, I have not been served till now. It has not been served. Until it is served, it is communicated. It cannot be given to effect too. But here, Malad, attending facts and circumstances, Lordship will definitely stay this for the termination order.
Oh, no, how should stay this terminated? It must be challenged. Bring it on record. You direct them to serve a copy forthwith. Take whatever steps you want. How can it be stayed?
Well, that's what I said. Malad, in the facts and circumstances of the case,
In
the
facts and
order,
circumstances,
the
you are
order was passed way back in
That's right.
9/1/2023.
Uh,
Then so-called notices was issued in the same year, reply was submitted in the same year. Only when
you serve a copy, you go through the termination order. we'll
only
take up.
when your lordship has passed the last order, perhaps this termination order has been issued thereafter. When the Malad revision, Malad infractions as to.
No, my lord, of course we can take a decision. Where is the bar, my lord? That we cannot take a decision.
I think the liberty was granted earlier by the
Yes.
earlier order. Okay? That
Yeah,
they
that
can
is
proceed.
That is there.
The only issue was that you were not allowed to join. There was no specific direction, I believe, subject to correction, that you were required to join.
Malad,
But you were required to be allowed. But natural
this is a-
corollary would be that when the order is set
Yes.
aside,
Yes. So
either you are required, permitted to join, or you should be kept under suspension.
in which will now present
We'll examine that.
termination.
Mr. P.J. Soikia, Senior Counsel,
Must
assisted
have
by
been
Mr.
issued
P.
from
Bodogo,
after the order that your lordship has passed.
appears for the petitioner, Mr. P. State and submits all instructions that pursuant to the proceedings undertaken. The writ petitioners have been dismissed by speaking order dated 16/5/2026. Mr. Soikia disputes the contentions. The writ petitioner submits that no such order has been communicated to the petitioner as of date. Did not receive.
I want to see.
Considering the same, let these facts be brought on record by the state government within 2 weeks. If any such order is passed, we not direct. It is up to them if they want to serve, or you want a direction. You want us to include in the order that a copy should be served.
Yes, yes, my lord. Then only I can challenge. Otherwise, it will not be communicated unless I file another writ petition. But this will otherwise not communicated to me unless I file another writ petition.
Copy of the
But
order.
today itself I
speaking
can serve to
order
the council, my lord.
dated 16/5/2026, be communicated to the petitioner as also to the council appeal. Is this matter after 3 weeks?
Let-
Wait, please, my lord.
Yeah, my lord. The finance department has, my lord, sent a second reminder, my lord, to the home and political department. Matter pertains to, my lord, grant of minimum pay scale. Lordship has already decided few matters, my lord. But here I am praying, my lord, for some more accommodation, my lord. Because these matters are coming up now and then, my lord, so we need to take a call, my lord. Because we are not the employer, my lord. This
What
is
has
the
happened to the SLP pending before?
It has
the
been dismissed, my lord.
SLP?
The writ appeal.
Huh? What?
They preferred the writ appeal against the.
No. SLP against Rupen Das.
So SLP it is pending, my lord. That final outcome is yet to be.
My lords, this matter we had relied on a similarly situated case of Rosity Das, where the government had preferred a rate appeal to submitted in the last occasion. The Honorable Division Bench has been pleased to dismiss that appeal.
That is true, my lord. Pursuant to that dismissal, my lord, the order passed by the coordinate bench of this honorable court stands. Pursuant to that, lordship has disposed few repetitions. But here, my lord, I am praying for some more time, my lord. Kindly accommodate, my lord, because lordship will kindly appreciate one aspect of the matter, my lord. We are not the employer. Eventually, we are to take the final call. So we are calling for all the data, my lord. Let the data come, my lord.
Who is the employer?
Employer is the Home and Political Department.
Home and Political.
Yes, my lord. Lordship will kindly see this is the second reminder we have issued, my lord. It is not that finance department.
Yes, Home and Political. Why are you not responding to the?
My lord, I will write a letter.
You serve a you give him a copy.
Right now, I will serve a soft copy, my lord. Right now.
Mr. R. Bondani for the Finance Department reviews its prayer for further time to instruction and the committee instruction as the information sought for from the Political Department. Mr. R. Bond representing the department submits that he will pursue the matter. Required information furnished to the Finance Department. Mr. Noah, Mr. D. It's again after 3 weeks.
My lord, on a fixed date, because a similar situated petition has already been disposed in terms of this order, my lord.
15th.
15th of June, my lord.
Yes.
His lordship may be pleased to keep my communication as a part of the record, my lord.
No, that's it. Just a reminder.
My lord. I'm so obliged, my lord.
Obliged, my lords.
Yes.
But matter relates to imposition of penalty pursuant to a disciplinary proceeding, my lord, of censure. But there is an order of your lordships, 2710, calling for the records, saying that it would be necessary. Thereafter, my lord, the records was received by the government advocate. So if the records, my lord, is available, then I can proceed, my lord. Otherwise,
Yes, Mr. Bora. Counsel for the parties. Meetings are exchanged. Matter be listed for hearing in the month of July. Meanwhile, the records necessary be
But in fact, records, my lord, has been
Please.
received.
placed
Because-
by the State Council at the time of hearing the matter be listed in the part two hearing list. For the month of July.
And can it be on June, my lord?
June,
Already, my lord,
Difficult.
yes, retired, my lord. Already retired.
June list is already ready.
Take a chance, my lord. Yes.
List is already out. Get it in July. Yes.
This is the matter.
I think so complete here, my lord. This may come up for hearing, my lord. It will take some time.
My lord,
What is your claim?
the claim with respect to increment of 3%, my lord, which we are entitled to under the ROP rules 2010. And this ROP rules 2010, my lord, it was notified in February 2010 and made effective from 1/1/2006. Now, so far as the petitioners before this honorable
Alright, we'll have to post it for hearing. Proper hearing will be necessary or we can
as
dispose of the admission stage.
so far as their affidavit is concerned, they do not deny our claim.
So who is to work out the benefit?
The finance department has come up with an affidavit which supports my claim, and they have also come up with an amendment in 2025. Only one thing that needs to be worked out, that under the ROP rules 2010, our promotions were effected post the ROP rules from December 2010 onwards in 4 batches: 2010, 2012, 2013, and 2015. Now, going by the affidavit, the 2025 amendment that they have brought into force, if that is that does not create a new right, it recognizes my right, and if that benefit is given to me since the date of promotion, it's certain, because they do not deny or challenge what we are claiming.
Right, the pleadings are complete in the matter. The matter be listed for
We
hearing.
have to file affidavit. We have received the bearers.
File it. List the matter for hearing in the month of July.
July.
July,
File
part
it
two
by
hearing
July.
list. Yes.
The admission is
Part two hearing list. You make a mention on any date, we take it.
I'm grateful.
And so, I appear for 1 and 4.
Mr. R. Borgundari for respondent number
2, my lord.
2, Mr. D. Bora for 1 and 4, R. K. Tarundar for
I'm
MLP
grateful.
is going for petition.
Yes, my lord, say slight accommodation for this payment next week. My lord,
38, counsel for the petitioner, raised for and is granted 2 weeks time.
My lord, she has given undertaking to willing to go to any place because of.
During the pendency of the writ petition.
Yes, my lord.
What is it?
Undertaking in additional affidavit, my lord.
The matter be listed again on 29th May
29 minutes.
or 28th May.
28.
28th.
And the interim is in operation.
Interim order passed early will continue in the next day.
Good evening. All right.
Yes, what records?
Chief, the records I have received just few minutes back.
These are the note sheets. Since it's an,
What is the challenge here?
he has challenged the transfer order, wherein he has been transferred from one district to another district.
It's a matter of frequent transfer, Your Honor. For last year, he has been transferred 4 times in the last year itself. And Your Honor has passed in status quo order on.
Why is he transferred?
On our affidavit, we have taken the ground there on account of administrative convenience in the interest of public.
But he's being transferred repeatedly.
Lordship, the present transfer, we have two grounds. Firstly, that he has been serving for 6 years in the one particular district, because of which he has been transferred from one district to another district, and that is by virtue of clause.
How can it be six years? He was transferred on 21.
No, in one district itself. Within the district, he has been transferred from one block to GP to block. But he has been serving in that one particular district for 6 years.
Now he's transferred out of the district.
Oh shit, inter-district.
Inter-district is not permissible.
No, it is permissible as per clause 11 of the guideline which he is relying on.
Normal course is within the district. In case they can transfer.
Then what is the ground for challenge?
Challenge is that he was being transferred frequently within the district itself, and lastly they have transferred him to the a mass distance place that is in into Dhemaji, Your Honor. Without any reason, Your Honor. And more specifically,
They have given the reason administrative exigencies.
That is the only reason.
What other reason you want?
Specific urgent reason has
What
to be.
specific reasons are required? You are a government servant, you will go as and where the duty
Yes,
is
yeah,
required.
but normal, as per their guidelines, normal tenure of service is 2 years, yeah. But he was transferred within a year 4 times, yeah. So when there is an exceptional case, then reason should be, Your Honor.
All right, you
And
go through the records and apprise the court why the transfer was made.
And Your Honor, one more thing, they have, during this pendency of this case, they have passed one another order. While there is a status quo order, they have passed one order whereby they have allotted another person in his place here. So it clearly shows their intention to accommodate other person in the place of the present petitioner. So it's the violation of the principle of the transfer here.
What does your record say regarding this transfer? You go through the records and apprise the courts. It is submitted by the standing counsel PNRB. That the records relating to the transfer of the petitioner has been received by him today. Like the same, and apprise the court thereafter. This matter on when can you apprise the court?
After we can.
Right, on 1st of June.
Can it be on the 3rd of June?
3rd of June. 3rd of June.
Interim
Interim order passed earlier will